So hi everybody, welcome back to Law Hero. My name is Jen and I do my best to bring you guys some law, whether it be FE1, barrister exam, QLTT, or just sometimes my own opinion about the law. And today it's kind of like a different topic, but one that we all need to be aware of, which is legal professional privilege. And if you're not already subscribed, please do. You just click the subscribe button, and if you like this video, please give it a thumbs up. And if you don't, well, it's too late. I've already filmed it. Legal professional privilege is really important because you should be able to go to your lawyer in confidence and discuss your case or whatever it is that you need legal advice for, without having that information divulged to the public. It's a confidential information. It's just like, for example, if you went to a doctor and you don't want that information divulged or made available to a third party. I have some comments and points to note around it, so if you want to know more, stay tuned. Why is this relevant? It'll be important for you when you train as a solicitor or a barrister. You need to know this as part of your professional conduct. But also, it's a common law. Privilege, and it is important for administrative law and constitutional law in Ireland. So, I mean, it's in every jurisdiction, but I'm just telling you the areas. The areas of law where it crops up. So basically, if you claim legal professional privilege, the onus is on you to justify why your communications with your legal advisor is privileged. And as I said, it's a common law right, and it's also in our constitution at Article 34. And as well as that, it's a fundamental right as seen in the European Charter of Human Rights, and there's been a lot of case law around that. It's Article 6, I believe. There's a few different branches of legal professional privilege. So the first one is legal advice privilege, and this is when your classic scenario, you go to a solicitor for advice or a legal advisor, and what you want is basically any of those oral advices or written advices, be it by email or by letter, that they are privileged and should remain confidential. Legal advice privilege only extends to protect communications that contain legal advice as to a person's legal rights and responsibilities, but does not cover legal assistance. So what does legal assistance mean? Well, legal assistance is, for example, drafting of contracts or documents in order to give effect to the intention of the client, and that's actually a very important nuance. The other type is litigation privilege, and obviously this is the advice your solicitor gives you when you are in litigation, whether it's existing litigation or it's reasonably apprehended, so you think it's coming, and this is written and oral communications as well. So the next question is, how do we determine what communications are privileged? So there's a test called the dominant purpose test, and this is where the court will take an objective approach, and this was actually recently seen in a case in Ireland in the Court of Appeal called Colston v Dunn Stores, where the Court of Appeal held that evidence required to discharge the evidential burden that rested on a party asserting legal privilege should be of sufficient quality and character to allow the court to make definitive findings about the motivation and or intention of the creator of the document over which privilege is maintained. So basically, what is the purpose of what is being advised? A bold assertion as to the dominant purpose of a document or the subjective state of mind of the party asserting privilege was not sufficient without evidence to support them. So it's not enough to say we intended that document to be privileged. within the document itself, there needs to be something. Normally you would see kind of on the header of a document, confidential, legally privileged advice or subject to contract, and that's the best way to cover you as to this objective intention in practice. Another interesting thing, as was seen in the Ahern v Mann Tribunal, which was about Bertie Ahern and what I got up to, is that litigation need not be adversarial. So when you say litigation, it doesn't have to be something whereby people are fighting out a certain matter. There is also regulatory or investigatory privilege, as was seen in Quinn v IBRC. It also applies to communications when you're trying to avoid litigation, which is very, very interesting. Now, what happens if a third party has become privy to your privileged communications? It's not automatically the case that if something is disclosed that is meant to be privileged, that it loses its privilege. There's a number of cases where the court will try and preserve privilege. So for example, if there's been limited disclosure, if there's a common interest in the privilege, as in for both sides, if confidentiality had been stipulated, and especially to the practitioners involved. Joint interest privilege, it's a further basis, and this is where a shareholder is entitled to see legal advice received by the company. That's why it's different to common interest. And there might be a voluntary waiver of privilege. So obviously waiver. But now we will move on to cases where there is loss of legal privilege. So the circumstances are as follows: where there's an intention to abandon privilege, so it's just like an outright intention, where the privilege is overridden by express language, for example by statute, where the communications is used to further a criminal or fraudulent purpose, even where the lawyer is not party to it nor is aware of it, in some proceedings involving children, in disputes regarding testamentary dispositions, and it's not been tested in this jurisdiction, but where there is an authority in common law which would allow it to do so. As I've already alluded to, there are a few places in our statute law, for example, Data Protection Act 2018, which implemented GDPR, where privilege will be lost. And I've personally seen this in regulatory investigations, for example, with our telecommunications regulator, with Central Bank of Ireland, that kind of a thing. Okay, so let's just take one look then at solicitors' duties when it comes to privilege. And actually, to be honest with you, this is the most important bit for solicitors. So a solicitor is under a duty to advise the client that they have a right to assert the claim to legal professional privilege and to make an assessment based on the state of the law as to whether a valid claim has arisen. So the onus is on the solicitor. A solicitor is under a duty to assert a claim to legal professional privilege on the client's behalf. So you have to be very, very wary that it arises on behalf of your client. Insofar as it's privilege of the client and not the solicitor, a solicitor is under duty to maintain the confidentiality of the privileged communications. In circumstances where it is evident that privileged documents were disclosed in error, and this is interesting, the solicitor should make all reasonable attempts to return the documents and should not make use of them. A solicitor must ensure that claims to legal professional privilege made in the second part of the first schedule of the affidavit of discovery are sufficiently articulated, and a solicitor should take steps to rectify the affidavit of discovery if it comes to their attention that the legal advice privilege or legal professional privilege has been incorrectly claimed in respect of a document. So solicitors have a really heightened duty of care when it comes to legal professional privilege to protect their clients, and the courts put the front loading of this protection on the solicitors. And again, I mean, it could be detrimental to a case if privilege was lost, unless, as I said before, it's lost for some of the reasons I've outlined in this video. So there you have it. What we've learned is that the onus is very much on solicitors when it comes to legal professional privilege. It's not for clients to know what documents ought to be privileged or not, and probably the best tip is to keep very little people on the case and kind of exposed to the advice in the case, and also to mark documents as privileged as you're going along. Hope you enjoyed this video. Hope it gave you some insight into litigation in Ireland, and see you in the next one.